Good evening. BJP leader Dr. Nishikant Dubey has run into controversy over his statement that if there is anyone responsible for stoking religious wars in this country, it is the Supreme Court. He made this remark during his larger observation that the Supreme Court is transgressing its boundaries and that if it carries on like this, then might as well shut down the parliament. Far from applauding his brave stand, one that resonates very strongly with a billion Indians, his own party has distanced itself from his remarks. This is cowardly and shameful because there was absolutely nothing wrong in what Dr. Nishikant Dubey said. Let me give you 9 clear-cut instances where the Supreme Court, in overlooking as well as overseeing blatant discrimination against the Hindus, not only seeded resentment, it stoked the possibility of religious wars in this country. Here they are. Number 1. On the matter of Kashmiri Hindus, the same Supreme Court that constituted a high-powered bench to look at the abrogation of 370, that was essentially a legislative decision, turned the other way when it came to opening the cases of criminality in 1990 against Kashmiri Hindus, saying, quote, too much time has elapsed. This after the same Supreme Court constituted an SIT to look into the cases of criminality in 1984 against the Sikhs that happened 6 years before the Kashmiri Hindu genocide. Their homes were seized and demolished, their jobs were snatched, their temples were vandalized, they were threatened, raped, kidnapped, killed. They were ethnically cleansed. And the Supreme Court, it said we will not reopen these cases because too much time had elapsed. If this is not seeding resentment among the Hindus and stoking religious wars, what is? 2. On the matter of the Waqf Act. For 30 years, the Supreme Court never found illegal an act that gave Muslims the power to claim any property as their own, that allowed them to annex any land housing a functional mosque. But today, it sits to adjudicate whether a version that curtails these draconian excesses is illegal or not, and opined moving waqf by user would be an issue. For 30 years, the Supreme Court never found unsecular an act that gave Muslims the power to use thousands of crores of taxpayers' money to conduct survey of religious property. For 30 years, the Supreme Court never found unjust that a parallel extrajudicial tribunal decided with finality the fate of the aggrieved whose land and property were usurped. But today, it sits to adjudicate whether a version that curtails these draconian excesses is illegal or not. Did the Supreme Court ever wonder what if the tables were turned? Because the truth is, every mosque in India is built on Sanatan land, including Jama Masjid. What if a Hindu board, armed through the Waqf equivalent Sanatan Act, laid claim to Jama Masjid? How would Muslims have felt if they had to first plead their case in front of a Sanatan tribunal rather than a court? For 30 years, the Supreme Court ignored the fact that the Waqf Act weaponized the Waqf board, allowing Muslims to annex 20 lakh acres in the last 10 years. World over, disputes over property are settled using courts and existing laws that are community and religion agnostic. Why was a particular community, Muslim community, armed with another set of laws? Those that were patently discriminatory towards member of the other community as a primary instrument of defense or indeed offense. If this is not seeding resentment among the Hindus and stoking religious wars, what is? 3. On the matter of state control of Hindu places of worship. State control of Hindu temples and their property is by far the largest, financially most damaging scam of independent India. Right under the nose of the Supreme Court that declares India is and must remain secular. You can have the state and the government give Hajj subsidy for decades, use taxpayers' money to host grand iftar parties, plunder state coffers to pay monthly salaries to thousands of Maulvis, ask government-run UGC to completely fund minority institutions that keep 50% seats reserved for minorities, step in to overturn a Supreme Court judgment just to appease Muslims, leech thousands of crores preferentially from Hindu temples, sell off and control thousands of acres of Hindu temple land, spend hundreds of crores of taxpayers' money for the Kartarpur corridor, run madrasas and still be secular. If you truly believe that religion should keep out of state, the corollary is equally applicable. That state should keep out of religion, but does it? Why is the state paying the surveyors of the Waqf board? Why is the state paying salaries to Maulvis? Why is the state giving interest-free loans to set up shops on Waqf and mosque land? Why is the state running madrasas? Why is the state giving hundreds of crores to set up Christian development corporations? How can the state be secular and at the same time control 110,000 Hindu temples? Should we be secular? Yes. But are we? No. A petition to free Hindu temples was pending in the Supreme Court since 2012. And now the Supreme Court has shifted the onus back on the lower court. Crucially, why doesn't the Supreme Court, that recently drew an equivalence, albeit a false one, between Muslim and Hindu run boards, have the guts to, in the interest of equivalence, ask the state to control mosques as it does temples? If this is not seeding resentment among the Hindus and stoking religious wars, what is? 4. On the matter of the right to education, or RTE. The Supreme Court has not only allowed but also ratified the conjunction of the Right to Education Act with the 93rd Amendment that forces only Hindu-run schools to give 25% reservation to the children belonging to the EWs or the economically weaker section. Muslim-run or Christian-run schools are not under any such obligation. This has resulted in thousands of Hindu-run schools being shut down. And because of this, thousands of Hindu parents are shifting their children to Muslim-run and Christian-run schools, an act that is subject to the possibility of conversion and proselytization. But the Supreme Court doesn't see this as discriminatory. If this is not seeding resentment among the Hindus and stoking religious wars, what is? 5. On the matter of free speech. If you ask me the textbook definition of a banana republic, I, as a free speech absolutist, would say that it is a republic where the Supreme Court stays silent on blatant violation of its own order. It has been more than a year since Udaynidhi Stalin wanted to eradicate Sanatan Dharma. A year since the Tamil Nadu government has been in direct contempt of the Supreme Court order of 2023 that said the state should immediately file cases in instances of hate speech. And yet, nothing has been done either by the state or the Supreme Court. I can only infer that eradication of Hinduism, comparing it to dreadful incurable diseases, calling it a menace upon the world, is not construed as hate speech by the Supreme Court. In which case, it begs to question, why did it so ruthlessly come down on Nupur Sharma for merely quoting Islamic scriptures and infer it to be hate speech? There is an ideology that specifically and unambiguously directs its followers to kill, maim, and convert non-believers and all those who profess other ideologies. It's a fact. The Supreme Court says that free speech does not include hate speech. Well, who decides what is hate speech? Polytheists, i.e. Hindus, are the worst of creatures, 98.6. Is this hate speech? Do not take disbelievers as friends unless they convert and kill them if they refuse, 489. Is this hate speech? You rush in to call any speech against Islam as hate speech, but call hate speech against Hinduism as any speech. You allow someone to burn Hindu scriptures, but order arrest of someone for burning a non-Hindu scriptures. If this is not seeding resentment among the Hindus and stoking religious wars, what is? 6. On the matter of Hindu religious and ritualistic practices. Milords, did you know, have banned animal sacrifice, even though it was a centuries-old tradition of worshipping the 10 Mahavidyas, and also in keeping with the 1954 Shirur Mutt judgment that established the sanctity of an essential religious practice. But the judges would hear none of it. Milords have also banned the 600-year-old tradition of animal sacrifice during Kullu Dashera. The question to be asked is, why should only the Hindu be prevented from conducting rituals? If the state is against animal sacrifice, and laudably so, then shouldn't it be against all animal sacrifices conducted in the name of religion? But is that the case? Do the judges have guts to ban halal, the ritual slaughter wherein the incision must be deep, that it cuts the carotid artery and the trachea? The blood must be drained completely, this while the animal is still alive. The head of the animal must be aligned to the Kaaba, and it is essential that Bismillah Rahman Rahim be uttered. Furthermore, only a Muslim can perform the slaughter. So according to the judges, this isn't a ritual. Now, the human pyramid height during Janmashtami has also been capped by my lords to 20 feet. Anything above would inflict harm to humans, say them. I want to ask them, during Muharram, thousands of Muslims openly inflict serious bodily harm to themselves and to others, with whips laced with steel claws that stab deep into the devotee's flesh. Is that not inflicting harms? But do our milords have the guts to ban this ritual during Muharram? It is the same with banning crackers during Diwali, but allowing millions of tons of stubble to be burned during the same month, or millions of trees to be cut during Christmas, or allowing fireworks during the New Year celebrations, because apparently only Diwali is increasing the carbon footprint and contributing to pollution. The rest are purifying the environment. If this is not seeding resentment among the Hindus and stoking religious wars, what is? 7. Places of Worship Act. In 2019, did you know, the virtue signaling Supreme Court in its Ayodhya judgment willfully ratified the Places of Worship Act 1991 that obligates maintaining all religious places as they were on August 15, 1947. Thousands of historical injustices can now never be addressed unless Parliament overrides both the 1991 Act and the Supreme Court judgment. Now, in a just world, this wouldn't have happened. A legal recourse to correct historical injustices cannot be denied in a democracy. Quote, no place of worship usurped or built upon another place of worship shall be allowed to be used as one unless its ownership is rightfully settled in a court of law, unquote. This, according to me, should be the real Places of Worship Act. As simple as that. Single sentence. But the existing Places of Worship Act blatantly discriminates against the wishes of a billion law-abiding Hindus. And it is only one exception, the Ram Temple. The one hallmark of justice is that it has to be applied universally. Because when one goes by logic, morality, first principles, objectivity, law, as science and law teach one to do, numbers do not matter. 4 or 40 or 40,000. How many criminal cases must you see before you say justice has to be done universally? 3, 4, 30,000, 40,000? Shouldn't each criminal case be applied universally and justice be meted out equally to everyone? Each and every cry of justice must be heard. But when one goes by fear, emotion, coercion, subjectivity, numbers matter. Well, it has been a very bitter medicine for the Hindus, I tell you. Our leaders feared the consecration of Somnath would herald Hindu revivalism, and the Supreme Court stayed silent. Our leaders gave away the most sacred Krishna Janmasthan fraudulently to the predatory Igda side, and the Supreme Court stayed silent. Our leaders promulgated the evil Places of Worship Act to deny us our legitimate right to reclaim our temples, and the Supreme Court stayed silent. If this is not seeding resentment among the Hindus and stoking religious wars, what is? 8. On the matter of the Sabrimala judgment. The simple question to be asked was it discrimination or perceived discrimination? Because the fact is there are many Hindu temples where the men are barred entry. And there are many Sabrimala temples where women are allowed entry. It is only in that particular Sabrimala temple that because of the vow of the deity to remain a brahmachari, menstruating women in a particular age bracket are not allowed entry. And as for menstruating women, it is forbidden for a menstruating woman to touch the Quran, recite a complete verse, enter a mosque, do salat, perform tawaf, fast, have sex, 56, 79, 2, 222 and Hadith Sharif. So are you now going to redact those verses? There is a fundamental contradiction between Articles 21 and 25 of our Constitution. If you allow one, you cannot follow the other. There are thousands of religious diktats that directly contradict Article 21, your right to life, dignity and liberty. If you are a true Catholic woman, you cannot be ordained as a priest. If you are a true Muslim woman, you cannot sing, dance, play sports, drink, fornicate, be a homosexual, wear what you want, or be an apostate. A Supreme Court that correctly removes discrimination from the Hindu religion, but cowers behind a lamppost like a wet cat when it comes to the other religion, is not a Supreme Court. It's a Sharia court. The Shah Bano judgment was overturned even though there was blatant discrimination. But the Supreme Court acted against centuries-old tradition of Sabrimala, even though there was perceived discrimination. If this is not seeding resentment among the Hindus and stoking religious wars, what is? 9. On the matter of the CA protests. The Shaheen Bagh anti-CA protests that resulted in the terrible 2020 Delhi riots were about the blockade, the blatant illegality of it. They were about Islamists and jihadis unleashing anarchy and wanting India to turn once more into the pre-1991 economic basket case. Disgruntled, hate-filled bigots blocking streets illegally, inconveniencing lakhs of commuters for no rhyme or reason, no logical argument, no rationale except to display a show of strength. तेरा मेरा रिश्ता क्या, ला इला इल्लल्लाह, हिंदुओं से आजादी, काफिरों से आजादी, हम लेके रहेंगे जिन्ना वाली आजादी, हिंदुत्व की कबर खुदेगी, शहादा रिप्लेसिंग द अशोक चक्रा, चिल्ड्रन वांटिंग टू किल मोदी एंड शाह. But the Supreme Court, despite recognizing the illegality of that blockade, went for mediation. It was blind to the inconvenient Shaheen Bagh post to millions of people. You have to ask, does the rule of law hold any meaning in this country anymore? Would the Supreme Court ask for mediation for everything that it says is illegal? What about the Sabrimala judgment protesters? I feel like a fool recalling that I had castigated them for breaking the law and the Supreme Court order. Perhaps I would ask for mediation henceforth. Let all the thieves mediate with the police. Let all corrupt mediate with the ED. Let everyone mediate instead of obeying the law. If this is not seeding resentment among the Hindus and stoking religious wars, what is? So in summary then, Dr. Nishikant Dubey is absolutely correct. Look, the concept of justice is at once man's greatest invention as well as the most dehumanizing. Emotions have no place in it. They are like chappals that have to be removed before you enter a temple, and in this case the temple of justice. A judge's pen is like a surgeon's scalpel. It must not shake on account of applause or abuse from the watching gallery, and that is why it is respected. My lords, you should be men, not gods. You should hold a pen, not a bolt of lightning. You should earn respect, not demand it. You should follow the law, not emotions. And you should not oversee or overlook blatant discrimination against the Hindus that seeds resentments and stokes religious wars. Lastly, you should be the ones apologizing to Dr. Nishikant Dubey. You.